So we're back. Today we're gonna be here talking about pretty much just like the system in general. And I got Angelo that I brought along today has been somebody that's shown me a few things. Pretty much, it's pretty much somebody that guided me through the rules, showed me some of the procedures. So, and it really helped me understand the courtroom system, understand like I almost call it like legalese. So, Angela, I'm gonna give it to you. I'm gonna let you take it away today, and we're gonna get into the courtroom system, basically.
Right. Well, okay. So, yeah, I just wanted to kind of go over like how my thought process and what I've been showing you over time. It all can be everything can be distilled down to like the basics. Like I try to as much as I can. I want to bring everything down to the binary, like a breath in and out. And look for those same features or traits and everything. So the court system I kind of learned is it's all about disputes, right? There's a controversy, and the controversy is that it's what's being uh, argued or claimed that's being brought into some type of adjudicatory system, right? So that's what the courts are. So um, I'm gonna share my screen. Okay. So law to me, like me personally, um, law can only be made by the creator, right? So everything else are just rules, man-made rules, and we have to agree to them or not agree to them, or even if you don't, there may be others that agree to play by their own rules. And one of the rules is that a rule is called law. So I guess it's like to give it a sense of hierarchy, So, but the rule is defined as a rule of action or conduct, and then substantive law is what tells what the rights and duties are and what constitute violations of such rights and duties. And then adjective law is tells how to enforce those rights and duties and redress wrongs. So adjective law is just another way of saying the civil procedure, right? Because this is what's operating right now in the U.S. You got different systems, common law, admiralty, maritime, commercial law, all of that, right? But for general, everyday things that we run across is it's under civil law. So civil law would be the substantive law, and then adjective law would give you the procedure on how to enforce those rights when your rights under substantive law has been violated, right? So I like to say another way of saying code of civil procedure is the code of instructions, civil instructions, right? But this is it. So everything is a uh, a dispute. So how do I know that? I go to uh, the code of civil procedure because that's
Right here. Mhm.
yeah, okay. So we go to the code of civil procedure. Now this lays I gotta go. This like going to this table of contents. You go to the beginning. So right here at starting at section 20, right? So this says judicial remedies are as such or such as are administered by courts of justice or by judicial officers empowered for that purpose by the Constitution and statutes of that state. So judicial remedies. So when you want a judicial remedy, that's what this is called. This is what's going on right here. These remedies are divided into two classes: actions and special appearances. I mean, special proceedings.
Right.
So when I'm needing to use judicial remedy, I got to fit within these two classes, either an action or a special proceeding. Then it defines what an action is. An action is an ordinary proceeding in a court of justice by which one party prosecutes another for the declaration, enforcement, or protection of a right. This is key, of a right, the redress and prevention of a wrong, or the punishment of a public offense. Most of the cases, either criminal or civil, but right here is the key. It's for the declaration, enforcement, or protection of a right, not the property, not anything else, just the rights itself. Every other remedy is a special proceeding. Actions, or just defined up here, are of two kinds, either civil or criminal. So those are two kinds, civil and criminal.
Right.
A civil action arises, comes about out of an obligation and injury. So an obligation is defined as a legal duty by which one person is bound to do or to not do a certain thing and arises from either, those come about by either contract or operation of law. An injury is of two kinds, to the person and to the property. An injury to property consists in depriving its owner of the benefit of it. That's all it is. This is what the injury is. To depriving the owner of the benefit of it. And then it tells you how. That's how the deprivation of the benefit is done by taking, withholding, deteriorating, or destroying it.
Right.
Every other injury is an injury to the person. So that's when you hit them bodily, hit by a car, somebody struck, move without their permission, stuff like that. A civil action is prosecuted by one party against another for the declaration, enforcement, or protection of a right. So all civil actions, no matter what you see anybody in court, no matter what it is, hey, Johnny sued him for $50 million because he slapped him or he did whatever, right? It's all this. It's only for the declaration, enforcement, or protection of a right or the redress or prevention of a wrong. That's all civil actions are. So now you can kind of look at everything that's going on. What is this person saying? What are they doing? Are they looking to declare their rights, to enforce the rights, or protect a right? What am I doing? What do I need to do? All right, so there it is. That's the only authority that's allowed to use judicial remedy or to get seek judicial remedy when those things are required. So penal code defines and provides for the prosecution of a criminal action. When the violation of rights submit to both civil and criminal remedy, the right to prosecute is not merged in the other. So there's no such thing as quasi-criminal and all this other nonsense you hear sometimes. It's only two, because here's the authority to bring the actions, right?
Yeah.
Let me see. There's another one. Is it in here? Not that one. I think that's in the civil code. So now I'm gonna go to the civil code. So another thing too is like understanding what civil law is. Like that's a whole system. So how does that work? This is civil code. The civil code covers persons, property, obligation. We just read what an obligation is, right? It's a legal duty. So let's go to person. Personal rights under the civil code. Besides the personal rights mentioned or recognized in the government code, every person, subject to qualifications and restrictions provided by law, the right of protection from bodily restraint or harm, from personal insult, from defamation, and from injury to his personal relations. These are the rights that they're talking about that are substantive, right? Now, don't forget, now this is just statutory civil rights. You got the Constitution, which the civil code acknowledges, but these are basically the rights that are enforceable or able to be declared or protected when you seek judicial redress or
Right.
remedy. When you seek judicial remedy, right? So um, from that, we have uh, agencies or there's an adverse party because there's a dispute. Doesn't matter who it is. It can be an agency, it could be a neighbor, it could be, significant other, whatever. It's going to still boil down to certain things, no matter the title given to it. So I just use the government's or governmental definitions because it's really like giving a blueprint of a dispute.
Right.
You see what I'm saying? This right here, this is the first one in the Constitution. The first. declaration, so to speak, in the Bill of Rights. All people are by nature free and independent and have inalienable rights. Among those are enjoying and defending life and liberty, requiring, possessing, and protecting property, and pursuing and obtaining safety, happiness, and privacy. This is a constitutional right, not a civil right. This is the highest right. And then in the civil code, when a statute or instrument is equally susceptible to two interpretations, one in favor of a natural right and the other against it, the former, the first being a natural right, is to be adopted. So that's what it's first supposed to look before making any type of interpretation. Now, this is in the Code of Civil Procedure. I think it's 1866, right? So we'll go back to the code. So I can just show you the source of it. 1866, right here. See, this again, this is the essential uh essential elements to what's going on with this system that we're in. Disputes, controversies. Now, the construction of a statute or instrument, the office of the judge, office also means function of the judge, is simply to ascertain and declare what is in terms or in substance contained therein, which is in the statute or instrument. Not to insert what has been omitted or to omit what has been inserted. Well, there are several provisions and particulars, such as construction, is, if possible, to be adopted as will give effect to all. So that's the rule for the judges when they're interpreting statute or instrument.
Man, that's
See what
key.
I'm saying?
That key is that not to insert what has been omitted or to omit what has been inserted. That's
Exactly.
the key right there.
That's the office of the judge. So that's saying that's the power of the judge, nothing else. Right now, these right here, person,
Mm,
includes any person, firm. Now we're not gonna get into the canons of construction because there's even a rule to how you're supposed to read this to see if it's applicable, if you're in the right capacity for this, any of this to
right.
apply. But my point is showing that like it doesn't matter who's here, regular person, natural person, or whatever. These are the basic components to any dispute, right? So when you look at the administrative code, which is what all of these agencies are, they create the Constitution creates a primary governmental um, tool or function or purpose, special purpose vehicle, right? To publicly administrate, to administrate the public affairs, right? And what happens when there's a dispute? These are the rules as to what, who's who, what's what, and what's supposed to be done. But again, reducing everything to its fundamental components, ultimately, what happens? They make a decision. A decision is an action by the agency that determines a legal right, duty, privilege, immunity, or other legal interests of a particular person. So when you hear in the news or you hear different things, you read and say, "Oh, so and so made a decision." The let me like the DOJ has made a decision, or the SEC has made a decision. That's what it's saying. They decided a legal right, duty, privilege, or immunity, or other legal interests. This again is a dispute. There had to have been a dispute in order for a decision to have been made, or else what are they talking about?
Right.
Right? You see what I'm saying?
Of course.
So here's a procedure on how they're supposed to conduct when they're adjudicating and making decisions. Now, all this is from the government codes, California government code, all this right here, right? But this is the overall structure. Even in court, it's the same structure. To me, they laid out how the courts operate, even though this is pertaining to an administrative agency. For example, right here, where it says a decision is invalid, this is from an administrative writ authority, which is out here 1094.5 of the CCP, or the Code of Civil Procedure, in which
Hmm.
it gives grounds for bringing the writ. You see what I'm saying? So
Yeah, that's one
uh,
I read under
if
right
they
now.
make a decision, this says you can have it reviewed if you exactly right. So if it's invalid, so what is the decision is invalid because of one or more of the following defects. Here are the defects: A, B, and C. The agency proceeded without or in excess of authority. B, the petitioner was denied a fair trial. C, the agency abused its discretion in one of the following ways. So there's abuse of discretion, but how? It did not proceed in the manner required by law.
Right.
Um, the decision is not supported by the findings resulting from the administrative hearing, and the findings are not supported by the evidence. So all of this constitutes abuse of discretion. You have one or more of these,
Yep.
right? Then we go into, here's another one I like. A right arising out of an obligation, right, is the property of the person to whom it is due. It may be transferred as such. So when I saw this, right, like this is just explaining to me it's all dispute. Like even more so is the declaratory relief, right? The uh, this part right here, right arising out of obligation is property. This is in California Civil Code section 1458. Okay. Now, um, actions for declaratory relief. This further like supports what I'm saying. Any person interested under a written instrument, excluding a will or trust, or under a contract, or who desires a declaration of his or her rights or duties with respects to another, or in respect to in over and upon property, or with respect to the location of the natural channel of a watercourse, may, in cases of actual controversy, there must be an actual dispute going on relating to the legal rights and duties of the respective parties, bring an original action, just we read what an action is, or
Right.
cross complaint in the Superior Court for a declaration of his or her rights and duties in the premises. So it's the same thing, right? He or she may ask for a declaration of rights or duties either alone or with other relief. And the court may make a binding declaration. We've seen what the office of the judge was, right? To declare the law of these rights or duties, whether or not relief is or could be claimed at the time. So this shows it's about disputes. The dispute is the controversy. And the rules of civil procedure are the instructions on how you enforce your rights by declaration, enforcement, or protection. You see what I'm saying? Like this is the uh, uh, end all be all as to why you even in court or dealing with any issue, no matter what it is. There's a dispute. Somebody claims that there's a right to performance by the of the obligation, or by the obligation of the one that has the duty to perform it. That in itself is the issue before the court. A claim of right to performance. You see what I'm saying?
Right.
And from there, everything else can be uh, measured and determined by running these tests through these requirements, and figuring out what's going on.
So like when we get into rights and duties as well, so like individuals have rights, and then the I would say the government has duties to not infringe upon those rights per se.
Exactly. Right. So who's the one that has the higher position at first? The people, because uh, governmental parties are what they take an oath to faithfully perform their duties, which is their obligations.
Correct.
Right. and respect the rights of others. So, but when you become a licensee or you become an applicant for benefits or recipient of benefits, then your role changes. You become a grantee of that right. You know what I'm saying? You become the one with the duty, and that's how the things flip. But it still comes down to rights, duties, and obligation, and application. Who is it applied to? But this is the basis of it. So yeah, that's what I'll try to show first because it's easier for you to figure out what the problem is or what the dispute is, so that you can work towards uh, the resolution or settlement or satisfaction of the dispute.
Um, I got a question for you. When you know, right when you're talking about the substantive law and the procedural law, right?
Mhm.
So, okay, so like as say like as a police officer, you're seeing in you know you're writing up on a possible uh crime per se, a violation of the penal code.
Mhm.
Now there is a crime report per se, or I would categorize that as a complaint. Okay. So now as that is created, are we in substantive law at this point, or are we getting when do we get to procedural law? Is it once the DA picks it up?
Well, no, the police officer is not making a complaint. The police officer is making the report of a complaint.
Okay, got you.
You know what I'm saying? And the procedure that when you're making that report is part of the procedure of making that complaint because is being prepared for prosecution, right? And it's not prosecuted until they bring action. What's the definition of action? Right? The prosecution of one against another for the redress or prevention of a wrong or public offense.
So that's when the DA decides to press charges, is what you're saying at that point when when the district attorney actually brings the complaint.
When they bring action, right?
Okay, they bring the action. Okay, gotcha. And then that's it, and then I would take it that's where we switch into the procedural law.
Yes. Well, you begin the procedure by the complaint. The police officer brings the procedure by the making of the complaint because somebody has made one, right? Or willing to make one in which you begin or the peace officer begins the process.
Got it.
That makes sense?
Makes sense.
Yeah, so like even when police when they arrest or bring someone, and if it's not on behalf of the city, like a person causes the agency or one of the employees injury, there has to be a complaint. If Walmart or one of these grocery stores or whatever, if you've been arrested or somebody's been arrested for that or is being prosecuted, there must be a complaint by that party, not the police, not anybody else, the state, because they're not the injured party. Right? We read what injury is.
So yeah, so the police can't be the injured party per se.
Right. Exactly.
I think I see. I'm trying to think where have I seen that where they'll act as the injured party, but they're really not. Maybe disturbing the peace. I think I've seen that before.
Yeah. That what they call that a ordinance violation or something. Right. But you have to be subject to the ordinance. Really everything you have to read the definitions and enactments and stuff to see what it applies to. But again, it's all going to be a dispute, right? Even that. What's the dispute? Oh, you have a duty to obey the ordinance, or you see what I'm saying? Okay, well, now you got to prove it. Well, what's the application? Where's the authority for that? And that's why, sometimes a lot of them resort to trying to shame you. You don't think the law applies. There's millions of laws. You know, SEC laws don't apply. I don't sell securities. So what does that mean? The law doesn't apply. What law? What are you talking about? You know what I'm saying? That
It's like
becomes a
I remember
dispute.
that. Yeah, it's like the Vatican sending me a notice saying
Right.
all Catholics have to pay. I'm like, man, I'm not Catholic, man. I'm not subject to this.
Exactly.
They say you're in the
Or you don't like
anti-Catholic
Catholics.
jurisdiction. I'm like, man.
You don't like Catholics. They ever start doing that. All of that
Man,
is insane. But yeah, it's still a dispute. still a dispute
Okay.
at the bottom line.
I want to go over one thing. When you went in, it was the judges as far as not to omit. Where was that part at?
Oh yeah,
Because that's a key point that I've run into a few times. And I want to call it when they're recasting everything. So it's an issue that you run into with the attorneys a lot, where they're recasting
right,
what you're doing, and then the judges. If you don't, I can say I could have held my position better or understood it better, but that's where the judges went outside the box before. And I found like in a couple of my cases, the judges went outside of the pleadings at that time. So, yeah, not to insert what has been omitted or to omit what has been inserted. So, if you're dealing with a judge or even a opposing counsel or like the other side, another attorney, and that's
right.
what they're doing, what do you think is the better way to?
So all of this, okay. So again, with court, right? There are rules as to how you bring a dispute or how you can make a dispute. Some are outright prohibited. Some is permitted, but unless it's objected to or rebutted. So in a situation like that, the objection would be as soon as facts not in evidence, or if facts have been established, as soon as facts that are in dispute. See, there it is, dispute. See what I'm saying? So that's an objection. If they're doing that and they're going outside of it, then you have to object to it.
Okay.
That's so there's uh every situation that you run into for the most part, like there'll be a procedure or an instruction on how to deal with it. Or that's another thing. Like if it's false, right? You might also want when you object that as soon as facts not evidence, may also want to strike it from the record. Like you know what I'm saying? Objection as soon as facts not evidence or non-responsive, move to strike. So you can move it from the record because that's what the dispute is. You're also in making a complaint, you're making a record of it and its prosecution so that you can show or each party can show that they had a fair hearing to uh, to address the matter or to settle the matter. That's part of the fair hearing part in the due process. See what I'm saying?
Yep. Yeah, I see that all the time. But yeah, making that record, take it upstairs, I guess, if you have to.
Well,
But
that's really what you're doing. You're preparing to take it upstairs if need be, but never treat it like it's the first instance. You always want to prepare for a possible review. So that anybody reviewing it can show that they had a fair chance to address their dispute, and I got a fair chance to defend it, or so on and so forth, to deal with this issue fairly. That's the main thing.
so let me understand this, like, because I can see, okay, so I can be prepared in my mind. Okay, so that if the judge does a minute order and then he does or a statement of decision, and then he's bringing up something that wasn't in there, like, or he's ruling on something, bringing in something exterior. So he's inferring certain things, but that's not in the moving paperwork on either side. So, and now you get this order. So what strategically I'm thinking would it so it'd be to oppose it, put it on the record and oppose it, and then also move to strike it? Would that be the proper
Well,
procedure?
that would be an objection. Yeah,
Objection.
and a motion to strike it if you want, to address it. But yeah, that would probably be the first thing is to object to it and the grounds. Like any objections have to be on the grounds that you're objecting and valid grounds.
Right.
So that would be outside the scope or again, soon as facts not in evidence or in dispute. And unless they do a formal finding, that's another thing. So now you got a due process violation because they haven't given you a hearing in order to make those findings. All facts have to be, especially when they affect your case or affect a case, it has to be fairly heard and adjudicated.
Now, when you do those objections, is that just a notice of objection, or do you actually like in the objection and the strike? Is there any ruling on that, or is you just putting a notice of a strike? Like who would rule on that?
Well, the judge would because the main thing is just making a record.
Right.
So and then it depends on what type of, you know.
Okay. Yeah, I'm just thinking procedurally how to handle this. Okay. Makes sense.
Words in papers, words in books, words on TV, words for books, words of comfort, words of ease, words to make the fighting cease. Eat your words, but don't go hungry. Words have always nearly hung me. Words are stupid, words are fun. Words can put you on the run. Concrete words, abstract words, words to tell you what to do. Words can put you on the run.